Very good day to Dr. Muhammad FIRDAUS bin BIDIN and all viewers. My name is Phrasaddha Naidu Puspakaran and my metric number is 255843. Today, I will be presenting a case review on the case of Lim Baba vs. Public Prosecutor 1962-28 MLJ 201 with emphasis on the elements related to the law of evidence. The brief facts of this case are as such. This was an appeal case from the Sessions Court which was judged by the learned Ismail Khan. The defense counsel was represented by S.M. Yong and the deputy public prosecutor was represented by Muhammad Saleh bin Abbas. On February 1961, about 2 p.m., a group of 6 friends went to a park where they later split into pairs. It is crucial to note here that one of those in the group was a police inspector. The victim, come complainant, was talking to a friend at a place far away from the others. While talking, the complainant and her friend were ambushed by the appellant and his companion. They hit the complainant's friend with a bottle before bringing her into the car. The appellant, together with his companion, drove the car to a cemetery where the complainant was sexually assaulted by both the appellant as well as his companion. They later released her at a place somewhere near her friend's house. The complainant rushed to inform this incident to her police inspector friend, who immediately brought her to the police station. By coincidence, on the way to the police station, the complainant spotted the appellant's car and she informed her police inspector friend about it. The friend brought her near the convent before going after the appellant's car. Whilst this occurred, the appellant had dropped his companion someplace before continuing his journey. The appellant then came across a police roadblock where he panicked and abandoned his car to escape when he was later arrested. At the trial court, the appellant was charged and convicted under Section 366 of the Penal Code for abduction and sentenced to 18 months imprisonment plus a fine of $200. The main issues subject to appeal and argument by the appellant relating to the law of evidence were as such. The first contention was that the president of the Sessions Court had misdirected himself in acknowledging the complainant's complaint as corroboration. Secondly, the appellant contended that the president of the Sessions Court was incorrect due to forbidding any questions by the appellant's counsel about her character. For corroboration, the legal provision referred was Section 157 of the Evidence Ordinance 1950, whereas for character evidence, the legal provision referred was Section 146 of the Evidence Ordinance 1950. For the appellant's court's decision, 4 contentions by the appellant's appeal were brought forward, and 2 contentions related to the law of evidence were addressed by the learned judge, which were as follows. The third argument was that the learned president should not have accepted the complaint by the complainant as corroboration. The learned judge in this instant case explained this matter with reference to the case of Rex vs. BIDIN, whereby it was held that a complaint made immediately could be treated as corroboration. Thus, the learned judge found that the learned president had correctly accepted the complaint as corroboration. For the fourth argument, the appellant contended that the complainant should be allowed to be cross-examined in order to impeach her character. The learned judge in this case found that, as the prosecution relied almost entirely on the corroborated evidence of the complainant, it was especially relevant that a cross-examination to impeach the complainant's character should be done. In a general basis, the judge deemed that character evidence is relevant if the character of the witness is related to the fact in issue or the credibility of the witness. On this ground, the appeal was allowed and therefore the case was remitted to the Sessions Court. The elements I had reflected from this case are as such. For corroboration, Section 157 referred in this case was specifically applicable to self-corroboration. In this instant case, the complaint by the complainant was used relating to the sexual offence which the appellant and his companion had performed on the complainant. The requirement that a statement must be made at once or shortly after getting a reasonable opportunity was fulfilled, as the complainant had lodged the complaint shortly after being victimized by the appellant and his companion for illicit sexual intercourse with no any unreasonable delay. Furthermore, with relation to character evidence, under Section 146, the appeal stated that the questions that tend to shake the complainant's credit by injuring her character should have been allowed. The assessment of credibility of the complainant in this instant case consists of the concept of truthfulness and objective of reliability. The concept of truthfulness is assessed to determine whether the evidence of the complainant is to be believed in terms of character and consistency. Meanwhile, for the objective of reliability, it is determined whether the ability of the complainant is reliable as to recollect, explain, and not contradict to the evidence provided. The lessons I've learned from the research performed on this case are related to corroboration and character evidence. Firstly, for corroboration, I refer to 2 cases. In the case of Muhammad Yusuf bin Rahmat vs. Public Prosecutor, the accused had raped a 5-year-old girl at the kindergarten he operated. The court held there was no corroboration despite testimonies from the psychiatrist, grandparents, and aunt due to all statements of alleged rape emanating from the victim. Next, in the case of Katyayani and another versus Lee Leong Sin, it has been stated that the rule is based on the assumption that consistency of utterance is the ground for belief in the witness' truthfulness. From these cases, I learned that although admissible, corroboration constitutes a very weak type of evidence, as it tends to defeat the objective of the general rule that a person cannot corroborate himself or herself. Next, for character evidence, I learned that the factor to be considered is the credibility of the witness. In the case of Sean Thornton versus Northern Ireland Housing Executive, it was stated that character evidence helped to assess the probability whether facts given by the witness are probable as whole, the weightage whether facts given by the witness is more convincing than the others, the presence of independent evidence whether facts given by the witness is consistent with other evidences, the demeanor or character of the witness whether the facts equivocate in cross-examination, and the motive whether the witness intends to mislead the court. I further learned that if it is established through character evidence that a witness is uncredible, according to the case of Dalit Bhagwan Singh versus Public Prosecutor, the bad moral character of a witness may impair the regard for truth. Less weightage would be given because witness is of bad character. Moreover, through the case of Tua Kindling versus Public Prosecutor, I learned that in character evidence, if a witness is successfully impeached of his or her credit, the court may reject the evidence entirely or sieve with due caution and care, accepting the parts considered creditworthy and reliable. In terms of corroboration, I wholly agree with the decisions by both the trial court and the appellate court. Corroboration is a matter of practice and prudence, not of law, and notably, corroboration is normally required in sexual offence cases. In this instance case, dispensing of corroboration allowed the complainant's complaint to be accepted as having established the case against the appellant. The reason corroboration is required in sexual offence cases is not due to the nature of the witness, but the nature of the offence, which is easy to allege but very difficult to prove. For example, in the case of Public Prosecutor versus Mandai, it was stated that there is no rule in the country that in sexual offences, evidence of complainant must be corroborated. However, it is a matter of common sense where it is sufficient if the corroboration is consistent only to the subsequent complaint by the complainant herself. The statement that implicates the accused should also have made the complaint at the first reasonable opportunity after the commission of the offence. Moreover, in the case of Zuki bin Muhammad versus Public Prosecutor, according to practice and prudence, corroboration was desirable in sexual offences. However, the complainant's delay of 6 weeks to lodge a police report was not within a reasonable period or at the first available opportunity after the incident. Thus, the prosecution failed to establish a prima facie case, causing the conviction to be set aside and the accused to be acquitted. As a conclusion, despite the court stating in Katyayani and another versus Lee Leong Sin that corroboration is a weak type of evidence although admissible, in this instant case, it is considered to be required as a matter of practice and prudence, not law, due to the sexual offence committed by the appellant. Based on Public Prosecutor versus Mandai, the complainant's complaint was corroborated by the trial court and the appellate court due to its implication on the appellant and the complainant making it at the first reasonable opportunity. Unlike Zuki bin Muhammad versus Public Prosecutor, the complainant had not constituted any unreasonable delay and thus the courts had rightfully allowed for corroboration. With regards to character evidence, I disagree with the decision of the appellate court and sustain to the decision of the trial court. Accordingly, cross-examination should not be allowed on the complainant, as they impeach a character as decided by the trial court. In sexual offence trials, introduction of character evidence tends to humiliate and degrade the victims. The victim's character or previous sexual life has no validity to determining whether there had been consent in the instant case. The victim's consent to sexual intercourse with a man does not necessarily mean she would give consent as well to any other person. If character evidence is allowed, it might result in discredit of the victim's testimony against the accused and allow the accused to obtain an easy acquittal. Moreover, it may also cause harassment by questioning past sexual life of the victim, double trauma due to humiliation at court, and become a major reason for the low rate of conviction in sexual offence trials. As a conclusion, the credibility of the complainant should not be impeached under character evidence, as this is a sexual offence trial, which is unlike the cases of Sean Thornton, Dalit Bhagwan Singh, and Tua Kindling. The appellate court should understand that sexual offence of the appellant and his companion has no logical link with the alleged good or bad character of the complainant. The complainant should only be required to prove her testimony and not be harassed by questioning her character nor her previous sexual life. Thus, the appellate court should have rightfully sustained the trial court's decision for not allowing cross-examination and upheld the charge and conviction of the appellant.